the member and call the member for Fisher.
Thank you, Madam Deputy Speaker. I rise to speak on the Public Interest Disclosure Amendment Review Bill of 2022, acknowledging that once again a large proportion of what has been brought before us today stems from coalition policy. At the outset, I want to acknowledge the hard work of those who work exceptionally hard to keep Australians safe through our counter-terror, intelligence and national security agencies. The wider community will probably never know the sort of work that they do to keep Australians safe. We also want to acknowledge the hard work of all of our public service. And as a person who came from small business, I really didn't understand the hard work that many, if not the vast bulk of our public service actually perform until I was intimately involved with them. As a small business operator, you always have that, I suppose, cavalier approach to public servants. You know, they start at 9 and knock off at 5. And having now worked very closely with both the Queensland Public Service and also the Commonwealth Public Service, I can say very strongly that the public service is full of very, very hard-working, diligent operators that are committed to the benefit, for working for the benefit of their fellow Australians, and I commend them for the work that they do. In government, the Coalition led significant reforms to the way our intelligence community and law enforcement agencies operate, with record funding and outstanding results. However, while both sides of the House have worked to equip our agencies to contend with emerging threats and advancing technology, the accountability mechanisms have required modernisation in line with the same threats, technologies and community expectations. The Coalition has taken the imperative of modernising this space very seriously, which is why we're working with the government on this bill, which is very similar to the legislation we brought into this place when we were in government. In that sense, much of the bill is uncontroversial. However, the bill is currently the subject of inquiry by the Senate Legal and Constitutional Affairs Committee. The bill amends the Public Interest Disclosure Act 2013, the PID Act, an act which allows public officials to disclose wrongdoing in the Commonwealth government sector and facilitates their investigation. This act had bipartisan support and allows a public official to make internal public interest disclosures to any supervisor, an authorised officer in an agency, the Commonwealth Ombudsman or the Inspector General of Intelligence and Security. When we talk about authorised officers, we're referring to the head of an agency or someone appointed in writing to receive those disclosures. In a narrow range of circumstances, public interest disclosures can be made externally, but usually only after an internal disclosure is made. The Act also sets out agencies are obliged to investigate a matter in relation to such a disclosure. The point of this kind of statute is that a disclosure ought to receive protection from reprisals and civil, criminal or administrative liability when they disclose disclosable conduct, such as fraud, serious misconduct, corruption or minor wrongdoing which meets the threshold. It is, in essence, whistleblower legislation. And the importance of this legislation, I think, is driven home with one of the best examples, most recent examples. It was in relation to the DNA lab in Queensland. Now, there is a great example that the entire criminal justice system in Queensland was pretty much predicated on, in serious offences, upon evidence being tested at this DNA lab. And what the terrific work that was done by Walter Sofronoff, QC, in his report into that DNA lab was found absolute systemic failures. He made 123 recommendations. It is a blight on the Queensland criminal justice system. It is a blight on the Queensland government that the DNA lab was left to some appalling circumstances of management, and it has unbelievably resulted in such travesties of justice where many people may never see justice. Many people who may have committed offences may never be brought to justice. And this bill, which amends the PID Act, is a very good example of the importance of protecting whistleblowers. We know under the current bill, under the current Act, I should say, that many whistleblowers did not feel adequately protected. Now, I'm probably conflating two different issues. My concerns in relation to the DNA lab is specifically in relation to Queensland, and I should make it very clear that this is a Commonwealth piece of legislation, and I'm not seeking to draw any comparison or any conflation between the two. But there is a very salient lesson here, and that is when whistleblowers don't feel as though they're adequately protected or want to be whistleblowers, such that they then don't make those complaints, then bad things can happen as a result. And I think I know the attorney well enough to say that those sort of issues would weigh very heavily on his mind, as they should, as the senior law officer of the Commonwealth. In relation to the bill in question, there are concerns that, as I said, that whistleblowers don't feel supported. They feel that their disclosures have not been taken seriously. In some instances, they have experienced reprisals. At the agency level, it's been found that the procedures are unclear or overly complex, and that the kinds of disclosable conduct are too broad. This disincentivises the disclosure of relevant conduct. As a result of these issues, the previous coalition government invited Philip Moss in his statutory review to offer recommendations. There were two joint parliamentary committees, and they offered their recommendations. The bill in question today largely implements the recommendations from a series of reports, which were agreed in part or agreed in principle by the previous coalition government. In particular, the bill implements 21 of 33 of the recommendations made by Philip Moss in his 2016 review of the Act. It also implements the recommendations from the Joint Committee on Corporations and Financial Services Whistleblower Protections Report in 2017. And it implements recommendations from the Parliamentary Joint Committee Inquiry into Press Freedoms in 2020. This includes the removal of personal work-related conduct from the PID Act, unless that conduct relates to system wrongdoing or reprisal action. The bill provides increased flexibility as to how disclosures are handled. It also extends the protections from reprisals to witnesses and those who may not yet have made, but have proposed to make or could make a disclosure. The bill includes new information sharing provisions. It allows other investigative agencies to be informed about matters within their remit. These changes have come about in response to the Moss Review recommendations. They address a known problem in the PID Act whereby the secrecy offence unnecessarily hampers agencies' ability to respond to wrongdoing in their own organisation. They allow smaller agencies to refer a disclosure to the portfolio department, avoiding tying up small bodies in investigative red tape. The Coalition supported these recommendations in its response to the Moss Review, and I welcome the changes to the PID Act from this bill. Madam Deputy Speaker, we all have an interest in ensuring that wrongdoing in the public service is not only identified, but that it is addressed and, perhaps even more importantly, that it is prevented. A strong whistleblower legislation will put people who are maybe on the cusp of thinking, should I or shouldn't I? Should I do this wrongdoing? Shouldn't I? If they know that the colleagues that they work with have appropriate protections to be able to bring that wrongdoing to the attention of appropriate authorities, then the intent must be that they won't then go perform those acts of wrongdoing. We've all taken seats in this place, in this parliament, to make a commitment to foster our democratic institutions. The people who elected us here expect nothing short of our utmost integrity, and they also expect nothing short of those who earn money on the public coin, our public servants. They expect our public servants to also be doing the right thing. They also expect us and our public service to call out wrongdoing. This is about a culture of trust and ensuring confidence in our system of government. It's about protecting the rights of those who have committed themselves to the public service. And may we never forget that important duty as members of this place, and I commend the bill to the House.